Welcome everyone to Current in 30, the 30-minute webinar series brought to you by the Current Consulting Group. We are thrilled to have you with us. To briefly introduce this series, each session is designed to keep you informed, efficient, and ahead of the curve. On the second and fourth Mondays of each month throughout 2026, we'll break down key things you need to know about workplace drug screening, from emerging trends and regulatory updates to best practices and practical implementation tips. If you missed our previous sessions, please visit our website, currentconsultinggroup.com, or our YouTube channel at Current Consulting Group to view those sessions. Thank you for joining us today. I'm Greta Walsh of the Current Consulting Group, and today's presentation is titled 3 Things You Should Know About Marijuana Testing. This presentation qualifies for half of a professional development credit from Sherman HRCI for those who attend today's presentation in its entirety. Today's presentation welcomes Senior Legal Consultant of the Current Consulting Group, Yvette Farnsworth Baker. Yvette is the Director of all law-related services, including Current Consulting Group's extensive compliance services. Yvette is a licensed attorney and member of the Florida Bar. As an expert in drug and alcohol testing case law, Yvette regularly consults on issues involving state law and federal regulations, in addition to authoring articles for industry publications. She also helps produce content for Current Compliance, the most comprehensive and up-to-date online database of state drug testing laws, including marijuana and workers' compensation laws. And now it is my pleasure to turn it over to our presenter, Yvette Farnsworth Baker from the Current Consulting Group.
Thank you, Greta, and thank you everyone for being here today. I am talking about what I think is one of the most important topics when it comes to workplace safety and drug testing in the workplace, which is marijuana. I'm going to tell you the 3 things you need to know about marijuana testing in the workplace. So let's go over the agenda really briefly. So the first thing that I think is the most important thing to know about marijuana in the workplace is that marijuana is the most used substance by employees. So we're going to start out talking about the current landscape of marijuana use in the workplace, the legal status of marijuana across the country, and that sort of thing. The second thing that I'm going to talk to you today, the second thing I think you need to know about marijuana in the workplace is that testing for marijuana is legal in all 50 states. So we're going to go over in part 2, state marijuana laws, medical laws, recreational laws, the atypical frameworks for marijuana testing across the 50 states. The third thing that I think everyone needs to know about marijuana in the workplace is that testing technologies today do offer solutions for the restrictions on marijuana testing. So we're going to go through some drug testing technologies, recent use detection methods, ways that employers can still test for marijuana despite any state limitations or state restrictions that state law imposes. And then we're going to wrap things up with some takeaways. So let us get started with our first section, the first thing you need to know about marijuana in the workplace. And we're going to come here to this really great graph that shows us that not only is marijuana the most used illicit substance, but it is the most used illicit substance by a lot. It is not even close. Here we're looking at a SAMHSA survey from 2024. And if you look at that blue wedge, it's showing people who used illicit drugs in the past year. And then it shows us what these people reported as using. And marijuana is far, far and above the #1 illicit substance used. Obviously, prescription opioids has been a huge problem in recent years, but if we look at prescription opioid misuse, it is a much smaller percentage of illicit drug use than marijuana is. Marijuana is being used by a lot of people. So right here we have a little map of legal marijuana laws across the country. And as you can see, almost every state has some form of legal marijuana. We still have a handful of states that have no legal marijuana whatsoever, but most states have, at very least, legal medical marijuana. And the blue states have legal medical marijuana as well as legal recreational marijuana. So the orange states are states with only medical marijuana that is legal. The blue states are states that have legal medical and recreational marijuana. And the gray states, some states have what they call CBD laws that, it depends on your interpretation as to whether you would call that marijuana or CBD. They do allow certain amount of THC. So those are kind of medical marijuana states, but very low THC. So 42 states have some form of legal marijuana. We also have been hearing in the news that the federal government is seriously talking about rescheduling marijuana from a Schedule 1 to a Schedule 3 substance. So that is going to make some form of medical marijuana potentially legal, even in the federal framework. As well, we have surveys saying, in a survey of more than 500 employees who use cannabis, over half admit to daily cannabis use, and almost half admit to having used at work, either during a break or while actively working. So that is a lot of people admitting to using marijuana every day, to using marijuana at work, which poses a real dilemma for employers who are trying to keep the workplace safe. This is a lot of people who are potentially impaired by marijuana in the workplace. Here's some more survey information. These are responses that came from employers. So employers, 52% of employers say impairment is decreasing the safety of their workplace. 43% of employers say impairment has increased workers' compensation claims. 45% saying impairment's causing misses, impairment's causing injuries, impairment is a problem in the workplace. So we have statistics showing a large number of people are using marijuana in a way that likely means they are impaired at work. We have survey data saying employers are concerned and employers do feel like marijuana is making the workplace less safe. So this is all important to remember. On the other side of it, what we also hear from employers is that testing for marijuana does make it harder to hire. There's concern about, can we test for marijuana? How do we test for marijuana in a way that doesn't get us, the employer, in trouble with lawsuits for doing it wrong or disciplining someone and now they sue us for wrongful termination or something like that? Or employers believe that it's not legal to test for marijuana in their state. Many employers say, oh, marijuana is legal, that means I can't test for it, correct? Or employers think it's not worth the trouble. Maybe I should just drop marijuana testing altogether. But most employers who are concerned with marijuana testing in the workplace are just overwhelmed and they're not sure how to do it correctly. So that is what we're here for. Here at Current Consulting Group, we're here to educate you on how marijuana testing can be done legally within the restrictions of the law, but in a way to keep the workplace as safe as possible. Marijuana is here to stay. Regardless of your position on marijuana, like as a moral issue or your value system, in the workplace, it is a safety issue and it's a business decision. It's negatively impacting operations. It's negatively impacting safety. It can negatively impact productivity. So employers need to have a plan, need to understand its impact on the workplace, and need to have a plan for how to deal with it in a way that keeps their workplace safe and running efficiently and running effectively. So let's come into section 2, testing for marijuana. Testing for marijuana is legal in all 50 states and in the federal framework. This is important for people to know because I do hear from employers who say, oh no, we're not allowed to test for marijuana. And we say, no, that's not true. Testing is legal in all 50 states. It's a question of how. How do you test? what are the laws in your state and what are the restrictions? Who are you testing? How are you testing? Where are you testing? So the most important laws to understand when an employer is trying to understand how to test for marijuana in their state. The medical marijuana laws, the recreational marijuana laws. A handful of states do need to keep in mind disability discrimination laws, and that is related to medical marijuana. If you have an employee who is a medical marijuana user and they claim that the marijuana is treating a disability, you need to be aware of how to test and discipline that person without discriminating against them based on their disability. And of course, we have the federal framework for federally regulated employers who need to understand how to test their regulated employees. So let's start out. Oh, I'm sorry. I have one more slide before we start out talking about state laws. Testing, yes or no. It does not need to be a yes or no question. It can be a question of how, who, and where, and when. It's important to know that for employers who operate in more than one state, one size does not fit all. One policy needs to cover employees in different states and have the policy language tailored for those state laws. There was a time when I started out working in this industry, it was very easy to have one policy on marijuana that covered multiple states. Marijuana could be handled the same way in almost every state, and we are not in that place anymore with the legal framework that exists across the states. It's very important to know the individual state laws for the states in which you operate and tailor your policy with state amendments that cover those specific state laws. So let's talk about, obviously the easiest states to operate in are states that have no legal marijuana. In states with no legal marijuana, employers can test for marijuana, employees can discipline for any positive marijuana test without restriction. So those are the easiest. Those are a handful of states still. The next easiest states are states that have medical marijuana laws, but they require no accommodations for medical marijuana users. And the good news is this is about 21 states. 21 states have legal medical marijuana, but they still allow employers to test for marijuana, and they still allow employers to discipline employees for a positive marijuana test, regardless of whether the marijuana is medical use or recreational use. An employer can still terminate employment, discipline an employee, anything under their policy for a positive marijuana test without restrictions. So I just have an example here of Alabama's law. The law does not prohibit an employer from refusing to hire or discharging or disciplining an individual as a result of their use of medical cannabis. So the great news is these 21 states plus the states that have no legal marijuana whatsoever gives us the majority of states where employers can still, without restriction, test for marijuana and discipline employees for a positive test, regardless of whether the use is medical or recreational. So next we have states that have medical marijuana, legal medical marijuana, but they put restrictions on how an employer deals with a positive test that is a medical test. This is approximately 21 states, DC, and then we have some city ordinances as well. So an example is Pennsylvania. An employer cannot discharge an employee solely on the basis of their status as someone certified to use medical marijuana. Now, I have had employers say, well, what if I discipline them on the basis of their positive marijuana test, but not on the basis of their status as a medical marijuana patient? Does that work? Unfortunately, the courts have consistently come back saying, no, that does not work. If the law says you can't discriminate against a medical marijuana user, that means you cannot discriminate against their use of medical marijuana. So if you have an employee who tests positive for marijuana and they respond either to a supervisor or to the MRO, and they say, oh, this is medical use, I have a medical card or a medical certificate, then you have to deal with those positive tests differently. An employer can discipline these employees if there is evidence that the person was impaired by marijuana at work. So it is just an extra step to take on top of the positive test. The positive test alone with no other evidence is not enough to discipline a medical marijuana patient. However, a positive marijuana test coupled with evidence that they were impaired at work or that they used marijuana at work or that they possessed marijuana at work or some other factor in addition to the positive marijuana test, then an employer can discipline that person. It just requires an extra step on top of the test. And this, again, is medical marijuana. So this would only apply to employees who have an official medical marijuana card or medical marijuana certificate, however it's dealt with in that state. So this would not apply to employees who are only using marijuana recreationally. If they have an expired card or they don't have a card at all, these restrictions would not apply to their marijuana test, only to those who are certified to use marijuana medically. So next we have a few states. We have about 10 states plus DC that have protections for recreational marijuana use. So an example I have here is the state of Illinois. It's unlawful for an employer to refuse to hire or to discharge an individual because they use lawful products off the premises and during non-working and non-call hours. Now, this Illinois law specifically includes recreational marijuana as a lawful product. We would say, yes, lawful product. Recreational marijuana is considered a lawful product in the state of Illinois, so an employer cannot refuse to hire or fire an individual because they're using a lawful product, as long as that use is during non-working hours and non-call hours. So again, testing for marijuana is still legal in these states. For example, Illinois. An employer can still test for marijuana. The problem is when they get a positive marijuana test, they cannot take adverse employment action based only on that positive test. There needs to be something else, another factor that allows them to discharge the employee or discipline the employee. For example, the easiest one is if there are signs that the person is impaired at work, signs that the person has used marijuana at work or possessed marijuana at work. So it's very important for supervisors to be trained to understand this, to be looking for signs of impairment in their employees, to be documenting signs of impairment in the employees. If they are documenting signs of impairment and then this person tests positive for marijuana, then that is clearly a circumstance where the employer can fire the employee, can discipline the employee, or something in that line. But the marijuana test on its own, with no other factors, with no other evidence, cannot be used solely to discipline someone. Now, we also have some atypical state laws. These are hard to put in a box. We have California and Washington that are a great example. In California and Washington, the law differentiates between drug tests that test for metabolites versus drug tests that test for the parent drug. And in kind of a layman's way to say it, urine testing is usually testing for a metabolite, whereas oral fluid testing, which is a saliva test, that is usually testing for the active drug, the parent drug of marijuana. So in California and Washington, the state wants employers to be using tests that are testing for the parent drug, for the psychoactive THC, and not for the marijuana metabolites. So an employer who's using an oral fluid test, a saliva test, can take discipline on a positive marijuana test, whereas if an employer in California is using a urine test that's detecting metabolites, and they will not be able to discipline an employee based on a urine test. So that's interesting to know. And there's lots of details to these laws that I don't have time to go into today. Washington is only pre-employment. I believe California has an exception for the construction industry. So there's a lot that goes into this, but it's just something to put on your radar. If you or one of your clients is an employer operating in the states of California or Washington, they're going to want to be looking at these laws and understanding the different types of testing. New York is the most restrictive state when it comes to marijuana testing. New York does prohibit most marijuana testing, not all, but most. So that is a really important one to know for employers operating in the state of New York. There are very limited circumstances under which an employer can test for marijuana. Generally, what we've been hearing in the industry is everyone is operating under the belief that reasonable cause testing is still permitted in New York. That means testing when there are signs that the person is impaired by drugs or marijuana or alcohol. That kind of testing is still permitted for marijuana, as well as any testing that's required by law. So federally regulated employers, state regulated employers that require marijuana testing, that testing is still permitted in New York, as well as reasonable suspicion testing where the employer or a supervisor sees signs that the person is impaired. Just really quickly, Minnesota has a unique atypical law. It prohibits pre-employment testing for marijuana, and it also prohibits marijuana testing that they call on an arbitrary or capricious basis, which they do not define. Thank you, Minnesota. But my interpretation of that is random testing. Random testing for marijuana would not be allowed in Minnesota, nor would pre-employment testing for marijuana, but other types of marijuana testing in Minnesota are allowed. So I'm sorry I'm running through these really quickly, but this is just to give you kind of some issue spotting to understand what you're looking for, what to research deeper when looking at employer policies. So every state, every law, every regulation in the United States allows an employer to prohibit employees working while impaired by marijuana. Every state law, every regulation, every city ordinance allows an employer to prohibit employees possessing marijuana at work or using marijuana at work. So at the very baseline, every policy in every state, even New York, needs to have a prohibition on working while impaired by marijuana, on possessing marijuana in the workplace, on using marijuana in the workplace. It's very important, and the bare minimum across even the most restricted states. So the way that we structure policies when we at the Current Consulting Group create policies with multi-states is we create a base policy. And in this base policy, the employer says what their company policy is, what their values are, their stance on the issues. And then if they operate in states that have restrictions, we add a state amendment for every single state in which they operate. And if there's a conflict between the base policy and the state amendment will govern. For instance, if you have an employer who operates in Texas and New York, and the employer says, I do not want to allow any positive marijuana tests for any of my employees. I want to test for marijuana in all circumstances, and I want to fire or discipline employees who test positive. We would put that in the policy. Then we'll have a Texas state amendment and we'll have a New York state amendment. And the New York state amendment will lay out New York's laws, and New York's laws will govern the employees that are in New York. And we will write it so that they can test in circumstances they're allowed to test for in New York. We'll write it so that they're prohibiting marijuana possession in the workplace, marijuana use in the workplace, impairment by marijuana while working for the New York employees. And then those restrictions will apply only for their New York employees. We also need for employers who have federally regulated employees, we have a special federal policy that complies with every, dotted I and crossed T in the federal regulations so that those regulated employees are being tested in strict compliance with the Department of Transportation's requirements, for example. Supervisor training is key. It's very, very important, especially in states that restrict employer discipline in some cases. If you can't discipline a medical employee solely on the basis of a positive medical marijuana test, supervisors are going to need to be trained on how to document the signs and symptoms of impairment. They need to be trained in looking for those signs and symptoms of impairment in the employees, and they need to be trained in how to document that so that the employer can take the action that they need to take. And employee education is very important. I'm going to skip through this because we're low on time today, but informing employees about what's expected of them is very, very important, especially in this day of legal marijuana, because employees may not understand that they are still prohibited from using legal marijuana by their employer. So we're going to run through the third thing that we need to know about marijuana in the workplace, which is that testing technologies offer solutions for recent use detection. The traditional sample type has always been urine. That is what was used for a long, long time. But now in this day of marijuana restrictions, it may be time for certain employers to look into new technologies that offer different options. As well, I just want to point out that the technology keeps getting better. The testing technology, especially for marijuana, keeps improving. Drug testing companies understand that testing for marijuana is a problem that is difficult for employers, and they are working very hard to find solutions to these problems. So I think employers should not give up on testing for marijuana, even in the most restrictive states, because the technology is going to catch up. The technology is going to offer solutions. It already is, and it's going to keep getting better. So oral fluid testing is a saliva test, and it, for the most part, is looking for substances that are currently in the body. It can detect drugs appearing in the body within minutes of use. And it's 100% observed. So it really does eliminate almost all drug testing cheating, because the collector is watching the donor give their sample the entire time. There's no going into a bathroom, closing a door to get a urine sample. You're face-to-face the entire time the collection is happening. This is what I was talking about a little bit earlier with California and Washington, where urine and hair samples are looking for, in marijuana testing specifically, urine and hair samples are looking for a marijuana metabolite. Oral fluid and breath testing are looking for the parent THC, the active psychoactive THC, and not a metabolite. So this is going to make a difference in some states. Now, I want to make sure that I have time to go through this at least very briefly, because this is very important when we're talking about states that are restrictive in how employers can discipline their employees. Many, many states, what their goal is they want employees disciplined for being impaired at work, but not for having used marijuana 5 days ago and still testing positive while at work, even though they're stone cold sober. Oral fluid testing is catching use within minutes, and it is not catching use that happened multiple days ago. Urine testing does not catch use that just happened. For the marijuana metabolite to get into the urine, it takes several hours, over 6 hours, for a marijuana metabolite to get into the urine. So between 0 and 6 hours, if a person takes a urine test, it's not going to catch that use. And then it continues to catch use that happened potentially weeks ago. Whereas oral fluid testing is detecting marijuana that was used within minutes, and then the positive will drop off very quickly, very quickly. I can't give you a specific amount of time, but a much shorter window than urine. An oral fluid marijuana positive is not going to be picking up marijuana use that happened a week ago. It's a much shorter window of detection, which is important in some of the more restricted states. So I think I am out of time. I think I'm actually over time. But like it or not, Marijuana is here to stay. Marijuana laws are going to continue to change. And everyone in the industry, all employers need to be kept abreast of the changes and what they can do to keep their workplace safe. It's really my personal belief that employers should not be sticking their head in the sand and saying, well, I'm just not going to worry about marijuana. I'm just ignoring that. They really need to be informed. They can do testing, they can do it correctly, but they need to be educated on how to do that, and have their policies up to date. And employers need to be keeping those policies up to date. A policy from 5 years ago is probably not still going to be compliant. A policy from 10 years ago, really is definitely not going to be compliant. So education is really important. And here at Current Consulting Group, we're the experts. We are here to help. So Greta, I ran a little bit long, but that is the end of the material I have for today.
Thank you so much, Yvette, and thank you to everyone joining us for today's edition of Current and 30. We hope that today's insights help you stay informed and confident in your workplace drug screening decisions. As a reminder, this presentation was recorded, and you will receive instructions in a few days informing you how to access the recording via email. Additionally, this presentation qualified for half of a professional development credit from Sherman HRCI for those who attended today's presentation in its entirety. If you have met that requirement, you will be emailed the activity IDs. Remember, we'll be back every second and fourth Monday of 2026 with things you need to know to stay current in this industry. Be sure to follow the Current Consulting Group and check your inbox for upcoming session details. Until next time, stay current and have a great day.